subsumed most of the recommendations in the previous report. Is the starting point, our strategic plan. As I said, in order for one to move as a leader, you must get views. And so I have my own view, which is we must move and have results. When Chief Justice Mutunga took over, it is said our backlog stood at 1 million cases pending. As CJ Maraga retired, we are, I think, at 600, 700,000. And the focus should be that, because what Mwananchi wants us to do is to give expeditious determination of cases. And that will be my approach. I know what Mwananchi wants. Go to any court, Kerugoya, Busia, meet any litigant in the court corridors. Ask them, what is one thing that disturbs them? I keep coming to this court. I've come to this court 5 years, 6 years. The focus should be instant delivery of service.
Thank you, my Lord. This institution has been trying to operationalize the institution of tribunals, which are part of the judiciary. I think it's Article 169 or thereabouts. Yes. Might my Lord know, one, what challenges we have met there, what success we have achieved, and what my Lord would do, in fact, the import. Let's take it this way. First, the importance of the tribunals, the challenges we have faced, my Lord, any successes, any, and whether the discharge of function of the tribunal is a distortion of the core mandate of the judiciary as regards alternative dispute resolutions.
Thank you, my lady, again. Yes, tribunals are described in the Constitution as subordinate courts, and so they ought to be part of the judiciary. Tribunals are important. They are specialized. The rules of procedures are not as strict as those of court, and so they dispense justice faster. It is so believed. Tribunals are become fashionable. Again, I've lost the number. I don't know whether they are 60 or 70. It's become fashionable for any legislation to have a provision for a tribunal, which is a good thing, as your ladyship has noted, as part of alternative ways of resolving disputes. We've faced challenges with the tribunals because the transition has been long. I believe there must be some resistance. If I was given the power to appoint people to positions, and this power is being taken away, I'll definitely, as a human being, may not be very happy. So I believe there's some resistance. I'm aware that we've made strides. There was a committee, I think chaired by my Lord Mr. Justice Ntoinoti, that made recommendations to the Commission as to which tribunals can move. And I believe with the recent decision by Mr. Justice Mrima, that we ought to finalize this as soon as possible. Looking at even the arguments before him, the Attorney General didn't seem to have serious resistance or problem with this process being moved. The main issue appears to be the legal framework, and I'm aware that there is a bill, 2019, which ought to be fast-tracked. And so I think the first thing that I would do, if you honor me, is to fast-track this bill so that we can be able to have them in. Tribunals are important, and that's why Kenyans in the Constitution thought that they are part of dispute resolution mechanisms and systems. And so they help us with these 700,000 cases. There would be more if tribunals were not there. So they play a critical role, my lady.
Thank you, my lord. Save that they are not the alternative justice systems. They are mainstream judiciary. And so the alternative dispute resolution mechanisms are those other ones, the arbitrations, the mediations, the AJSS, and the question still remains whether the alternative dispute resolution mechanisms may distort our core mandate. May they?
No, I don't think they'll complement.
They'll complement. Let's go to something else, my lord. And it is this. The magistrates, you, my lord, will agree, carry the greatest load of enabling access to justice in the institution. Is that a correct statement?
True.
Where are their decisions reported?
Yes, magistrates are the first port of call. They are the face of the judiciary. Perhaps 90 or 80% of Kenyans who come to court end up there. They make decisions. Unfortunately, the law establishing the Council for Law Reporting does not seem to recognize that. I was a member of the National Council for Law Reporting at its inception, and it's something we discussed. And it's something I think needs to be discussed further, because it is imagined that when magistrates make decisions, they are decisions that can be overturned immediately by the High Court, or confirmed by the High Court again, but overturned by the Court of Appeal, and therefore they do not have any binding effect. But something we were discussing in the council was whether they could have their own way of having their decisions reported. But again, for what I've just said, because those decisions can go up to the Court of Appeal, perhaps even to the Supreme Court in some instances. So why would we have different levels? What we do normally, even in the Court of Appeal, when you cite a High Court authority, we ask you, and I believe you do this also in the Supreme Court, we ask the person citing it whether that decision stands or whether it has been overruled or confirmed. Because sometimes people cite authorities that suit them, but authorities that may have been overruled. And so all I would say is that for that reason, that eventually the decision that will be binding are those decisions of the superior courts on the magistrates' courts, that it would be, I don't want to say a waste of resource, but it would be superfluous to have another law report.
My Lord, the NCIJ, which my Lord would be chair of, has not found it prudent to have decisions by the courts that discharge nearly 80% of the work we do. Last I checked was 70. Is that a gap? And so, what is my Lord Chief Justice? As Chief Administrator, I'm remaining there. Will shortly move to Chief Judge. What is my Lord going to do? Is it not important that the work that magistrates do should be reported? And if it is not reported in Kenya law, should it not be reported some other place, my Lord? Or is that what you're saying, we should not have another report?
Sorry, my lady talked of NCAJ. I got a bit confused, but I got the question. Is the Council for Law Reporting?
It is actually under NCAJ. That's right. The work of my Lord as chair there.
Right.
All these other bodies feed into that body, isn't it? And so, my Lord, the direct question is that Kenyan law, because of what reason, by the way, has decided that the work done by the magistracy should not, has so far not been reported. Okay? Is that a gap? Is that a good thing? And if it is a gap, then what would my Lord do to fill that gap? But if my Lord feels that it's okay the way the situation is, then you discuss with us.
I reiterate, there are many good decisions. I just shared with you some of my decisions when I was even a magistrate. And so there are many, many good decisions that come from those courts. They ought to find a place somewhere. But I think the issue is the law. The Act, I think, foresaw only superior courts' decisions. So it's a matter, perhaps, I'm not quite sure what, I can't remember now. If it's a matter of the law, then the law has to be amended.
Yes, it's my Lord's role as chair, as chief administrator of the judiciary, that my Lord would play towards getting this, I think, big gap being filled, right. Whether by amendment of the law, whether by some other form, that's what we're looking for. Let's go to what I think is my last part, second last actually. My Lord, as Chief Justice, would be chair the Judicial Service Commission. My Lord would be chair NCAJ, and my Lord would be all over the place, so to say, a minimum of 5 places. I call them 6 because of the rules function, and so many others that are not under statute. Now, that is time-consuming and would require very serious time management, planning how to utilize one's energy to still remain relevant in each of those many roles. Would my Lord please tell us what prepares my Lord for multitasking, and which role my Lord considers as the most important of the many hats my Lord would wear as my Lord Chief Justice?
Thank you, my lady. Yes, 5 very critical roles, very, very critical, head of the judiciary and all that. They are all equally important and must be given equal priority and chance. What prepares me to juggle this is the background that I've given you, that as registrar of the courts, I was able to wear more hats and was able to deliver without losing my head. As a registrar, you are an accounting officer doing a budget, defending the budget, accounting for expenditure. You are also what they call, I don't know whether it is still relevant, you are also the authorized officer dealing with HR matters. You are in supplies, as we called it then, a library, and even outside the country, you are a member of some community in a committee in the East African community. I went through all this, so my training, my experience and background prepares me to be able to wear these hats.
And to wear them effectively, my lord.
Yes, yes, my lady.
I don't feel that I should leave this area before we discuss just three, which are the most important priorities we have identified for moving us to the next level in our strategic plan on the core mandate of the judiciary 2019-2023. Would my lord kindly discuss very briefly those and tell us how my lord will ensure that we get there?
Thank you.
On the core mandate.
In the strategic plan, I think the strategic plan identifies 8 key areas. The first one would be on access. Access in its very broad term. Opening up courts, making work efficient, delivery on time. The second one is on issues of integrity, the strengthening of the Ombudsperson's office that has been identified too. And of course, there's the issue of leadership, enhancing responsive leadership in the judiciary.
On access to justice,
Honorable CJ, I hope you are winding up because time is going.
All right.
Thank you.
On access to justice, which is core, and on organizational sustainability, which also is core, and on the corporate identity, which is also core, I would imagine that one of the very serious issues we would have to settle would be this problematic caseload, how to manage it, so that we remain relevant. My Lord, as you hear, we've run out of the time allocated to me, but let me ask one final question. Judicial discretion. What is it? When may it be misused? And is my Lord aware of instances of misuse of judicial discretion? And my Lord, I wish you the best.
Thank you, my lady. The judicial discretion is the inherent power given to a judge or a judicial officer in law, in the rules, to make a decision. I know that in many instances we have properly exercised our discretionary powers, but I'm aware something that concerns me most, the discretionary powers used in interim orders, ex parte orders. That concerns me quite a bit. We have seen people running to court last minute to get such far-reaching orders which are issued ex parte, and sometimes we don't even reflect on the ramifications of those orders. That is one area. I can't say it is being misused or abused, but given the effect, I think it's an area that ought to be looked at very, very carefully. Thank you, my lady.
Back to you, Chair.
Thank you very much, Acting CJ. Thank you, Judge. It is now the turn of Commissioner Judge Wasame to ask his questions.
Thank you, Professor. Judge, again, welcome. Judge, you have talked about how you have transformed the Court of Appeal. Now you will be head of the institution of the judiciary, and in particular, you will be the president of the Supreme Court. Tell us one thing you see as a problem in the Supreme Court you will solve within your first 60 days, if given the opportunity, God willing.
Thank you. It's a tricky one. I'm not in the Supreme Court. I'm not able to identify a problem. But going by the current discussions, going by the general feelings, of course, there have been many criticism of the court, whether right or wrong. I personally think that we have had very good jurisprudential guidance from that court. Just read judgments of the superior courts below the Supreme Court, and you will notice that we make reference to their decisions. But there are criticisms. All courts are criticized, including our court. I think the Supreme Court, having done 10 years, there ought to be some audit, some introspection. The equivalent in the UK, which was born 1 year before ours, had their reflection period, where you introspect, look at whether these criticisms are grounded or are just hot air. And that's all I can say, that perhaps it's time for us as a court to have self-evaluation and even involve scholars, to help us really break down these criticisms. Thank you, my Lord.
My Lord, again, the timelines provided under the Constitution, under the Elections Act, in terms of resolution of election petitions, is designed to facilitate quick resolution of the dispute. From the magistracy, the High Court, the Court of Appeal, to the Supreme Court. Of course, I agree that there is timelines for magistracy, High Court, and the Court of Appeal, the 6 months. But I have not seen any constitutional requirement other than Rule 28 of the Supreme Court rules. I have also read the strategic plan of the court 2020-2024. Of course, it has a catalog of fundamental landmarks, achievement which the court has done. But one thing that is missing is the timelines for resolution of election petitions. I have noted from my own research, sometimes they take 9 months, others take 8 months, others take 12 months. So how do you intend to resolve that problem and ensure compliance with Rule 28.1 that provides 90 days from the last day of the hearing?
Thank you, my Lord. Apart from the presidential one, the rest don't seem to have timelines, election petitions that end up there. But your question concerns rendering of a determination within 90 days. Long time we used to have judgment on notice. I'm saying long time because it's been discarded in most courts. If you give a date for judgment and 90 days pass, I think the rules require you to explain why the date, the ruling or judgment has not been delivered within that time. And so if you go beyond 90 days and there's no explanation, then that ruling or judgment becomes one on notice, which is something that ought to be discouraged if it is there. People come to court with grievances, things they cannot agree on, things that are dear to their hearts, and they want results either way. And so if you do not render a decision within those timelines, which were set deliberately for a purpose, then you have not rendered justice. A colleague in our court says it is like cooking. You can't be in the kitchen forever. People want to eat, bring food on the table. We bring judgments on the table. So I'm not answering that because I really don't know what is the situation in the Supreme Court. I'm just giving a general answer as to the 90 days.
Thank you very much, my Lord. And secondly, you have also talked about how, under your leadership, the issue of the backlog and ownership of decisions by the Court of Appeal has been very impressive. How do you intend to translate that record all across the judiciary?
Again, the concern has been in a collegiate court whether we need to write separate decisions. When you write separate decisions, you are thinking, your philosophy is espoused. It is something provided, I believe, in most, or if not, perhaps all of our rules. And there's a reason why that is so. And so I would encourage people to write separately, but we face challenges when it comes to numbers. If you are each, like in our court, if you are each to write each time we had a matter, the time taken, you'd have done 2 others. And so, although the rules say as a general rule that separate decisions will be rendered, the reality is that it's not possible with our numbers. But it's an important thing to follow up.
Again, judicial officers all across the board have been accused of having inbuilt administrative nightmares and insensitivity to the citizens of this country. One area of concern to me is how sometimes we treat the elderly, terminally ill people and succession disputes. What is your idea of how to resolve or how to target those specialized litigants before court?
I'm told of an example of an old case at the Milimani Court of a paraplegic lady who has to be carried by people on the stairs up to the court. I'm aware we don't have ramps in most of the courts. I'm aware we have no braille facilities for those who are impaired in their sight. And there are so many categories of people who seek our services but are not able to get them. And if ourselves as judicial officers, judges, are not able to treat them when they appear before us with the respect, then that worsens their situation. So there are reports on how to deal with these categories. Even the task force I chaired had elaborate ways of dealing with that. The strategic plan that we have ways of dealing with this, really just to implement, to make sure that everybody who comes to court is catered for. Those who cannot hear, we have interpreters. Those who cannot speak the language of the court, we have interpreters.
Again, another area where we have been accused of being insensitive is that judicial officers keep files after the delivery of the judgment quite some time, sometimes even inhibiting the right to appeal. What do you intend to do about that problem?
Very true, perhaps not widespread. And the question is, once you deliver judgment, what is your interest with the file? That is a question of discipline, because once you deliver judgment, time kicks in for many things. People want to apply for stay, people want to extract orders to execute, people want to appeal. So if you keep the file and there is evidence that you did that deliberately, it wasn't in the typing pool, that's a case for indiscipline.
Again, another problem is how to get fines and deposits refund from the judiciary. That's also another nightmare. How do you also attempt to resolve that problem?
A nightmare indeed. When people come to court, you give a conditional stay, pay 2 million, and you get a stay, deposit in court. You come to court, you are fined. You are acquitted. Whatever deposit you place in court, that is your money. I'm aware in the past we used to have district treasuries. I'm not quite sure whether we still go there, but I'm also aware that almost up to 70 million shillings are tied in these district treasuries. And I'm aware too that there's a process to try and resolve that. Yes, but to answer your question directly, we must have a system, and I'm aware we're having JIFMIS that should be able to deal with issues of deposit instantaneously.
Another problem facing the judiciary also is the transfer policy for magistrates, judges, especially from the High Court. It is very effective in the Court of Appeal, as you know, but it is not followed for the High Court, the magistrate caddies and the staff. How do you intend to resolve that problem?
Transfers can also be described as nightmares. They disrupt families, they disrupt court work. It affects even litigants. And so when the judiciary leadership thought of having a framework, it was a great idea that people can plan. And as you have correctly, my Lord, noted, in the Court of Appeal, that is known. 2 years before you move to a next station. So your second year, the month of April, you start packing, and May you are in your new station. Nobody comes to say, I have a little child, I'm going to college. Nobody. It is something that has been accepted. The High Court and the other courts of equal status also have a policy. I know that policy has not been adhered to. I know magistrates and the judges who have been transferred within 6 months to so many stations, 2 or 3. There must be a way of institutionalizing this policy so that people know, people can plan. There's a financial aspect to it as well. If you move people, each time there's money paid as transfer allowance. The officers have to hire transport at the expense of the judiciary to move their household goods to the new stations. So there must be a firm policy that is known. Obviously, there are exigencies of duty. There may be a reason for a judge or a magistrate to be moved at once, but it cannot be very common.
Again, my Lord, you talked about having, during your short time as the President of the Court of Appeal, you have given an identity to the Court of Appeal in terms of delayed judgments, in terms of ownership of the decisions, in terms of getting debts within the reasonable time. How do you intend to give courts like the Commercial Division, which is sometimes unfairly accused of having lost its identity, the Labor Court, which is sometimes unfairly accused of being pro-employees court, the Land Court, which is also sometimes unfairly accused that it is a nightmare to get a hearing date from that court. How do you want to give those three divisions or three courts an identity?
Yes, the accusations are there, I've heard them. But we must understand the background why we have these accusations. It really boils down to numbers, judges. So when you hear that your matter that you filed in 2020 will not be heard until 2025, then you know something is wrong. So to begin with, the identity that they must be given is expeditious disposal, which they can only achieve if they have the numbers. They can also get that identity by being active in case management of the cases that are before them, to be able to identify which cases have been there long, and to identify those cases that are urgent in nature. But the whole thing boils down to capacity. Thank you.
And lastly, another nightmare facing the judiciary or the administration of justice, my Lord, is the Mariotetu case. The Supreme Court, respectively in my view, dealt with the circumstances, the degree, gravity, and the culpability and the exceptional nature of the death penalty in terms of Section 203 as read with 204. And what the court said, from my reading, I could be wrong, is that the two accused persons, and the court, let me start by saying, this decision, the court was very specific and said it only applies to these two petitioners, Mariotetu and Mangi. Again, the court did not set aside the death penalty, which was imposed by the High Court and also upheld by the Court of Appeal. But they remitted back the matter to the High Court for resentencing. And what the court was saying, in my view, is that a formal equal penalty for an equally wicked crimes and criminals is not in keeping with the tenets of a fair trial. And the court said, anybody who thinks there is a problem of the death penalty need not to approach us, but go to the relevant court, and then they come to us. And they said, the AG to set up a framework to deal with the sentence and rehearing of cases relating to the mandatory nature of the death sentence. Of course, the point I'm raising, my Lord, is that there has been a remarkable concerns that that judgment has been misused and abused and misunderstood and misinterpreted by all the courts, from the Court of Appeal to the Magistrate Court. and now it's free for all. How do you intend to resolve that nightmare as CJ Ouko?
Thank you, my lord. On a light note, I think Kenyans must be wondering this Muruatetu man that is being discussed in this tent from the time we started. Perhaps the commission may want to introduce him at the end of your exercise. He's a great guy. He very resilient. He brought a change to our jurisprudence. Muruatetu, a very resilient man. Having said that, perhaps we go back to the decision of the Court of Appeal just a month before the promulgation of the Constitution, the Ngothom Mutiso, where the court was faced again with the 204 crime, section 204. And the court was very specific. The court said this decision is limited to this case and to the mandatory nature of death sentence under section 204. And it went on to say that it perhaps may apply to the other capital offenses, and they named them: treason, robbery with violence, attempted robbery with violence. They said a day will come when that will be resolved. But for now, Ngotho's case ends with the determination that death penalty is not the only punishment that you can be given when you commit murder. Then, of course, came a 5-judge bench of the Court of Appeal a few years later in the case of Joseph Maura, and the same question arose, except I think Joseph Maura was robbery with violence, but the principle of the mandatory nature of the death sentence was still at the center of it. And the court said, we have no alternative. The law says you murder, you commit robbery with violence, it is death, nothing less. Then the Supreme Court came. The Supreme Court agreed with the first case, Ngotho, and said what it said. The two issues that I think have been raised, that after that decision, there's been confusion. I think the courts and the practitioners ran to town. The Supreme Court had said, hold, they had actually said what Ngotho said, that this case relates to the circumstances of this case. But the Supreme Court, in my view, said two things that perhaps has caused the confusion. The first is, I think, paragraph 48, which I think people have misread. Paragraph 48 of that decision, the court says that you cannot take away discretionary powers of a court in sentencing by an act of parliament, that is not the role of the legislature. Of course, they've gone on to explain again that it was really in relation to what they were saying. Personally, I don't think they were saying it generally. Then they asked the Honorable the Attorney General to come up with a framework, what they call structural interdicts. And I think perhaps people waited and became impatient. There was no direction, and we took the law in our own hands, hence the confusion. I can't blame the Supreme Court. Had we held our hands, had we waited for the framework, perhaps this confusion would not have been there. So what I'll do, if you allow me to, be the Chief Justice, because the Supreme Court did not finish its work. It gave an interdict. Have a mention and hear what the Honorable the AG has to say with regard to the assignment that he was given, now nearly 3 years, and you make a decision from there. Thank you, my Lord.
Thank you, my Lord. I wish you well. Thank you, Professor.
Thank you, my Lord.
Thank you, Judge Wasame. Thank you, Your Honor. I think we have now questions from Commissioner Judge Majaja before we take a break. Commissioner.
Thank you, Chair. Good morning once again, my Lord.
Good morning, sir.
One of the tasks I've been given is to deal with your writings, not necessarily to interrogate the reasons, but just to satisfy the Commission that you meet the standard, and I must say that they are very impressive. We have 4 judgments. The first one is in a civil appeal, Kenya Hotel Limited and Oriental Commercial Bank. Another one in Elizabeth Wambui Githinji versus Kenya Urban Roads, and a ruling in Judicial Service Commission versus Honorable Lady Justice Kalpana Rawal. What I read from those decisions, first of all, they are individual judgments. In 2 of them, you actually delivered the majority decision, and there were dissenting decisions. I think one of the issues I had raised with your colleague, and probably you followed that debate, and you've mentioned it, is the level of accountability for individual judges in the Court of Appeal or in a collegiate court to the public, being able to write your own decision. And my view and assessment, and correct me if I'm wrong, over the period the Court of Appeal has not done very well. You've been writing joint judgments, and when I look at other courts of your status, Supreme Court of Appeal South Africa, there are 5 judges, but normally, even when they agree, it is one judge who writes and he's identified. Look at Tanzania, look at Ghana, that's what happened. So maybe you want to tell the public why this is a different position. And in fact, if you look at the old East Africa Court of Appeal, that was also the position. That's why we know Madan, that's why we know Dewbold J said X, Y, Z. Why is that?
Yeah, thank you, my Lord. Yes, it is very important to not have known Nyarangi. Was a great judge, but his decision, one decision that has stood the test of time, the Lillian S, has his name on it. And so I can't overemphasize the need for a collegiate court to have separate opinions. It is in our court, there are those who think we should be doing separate judgments, but there are those who think that the reality is that the numbers cannot allow us to do that, because if you hear one matter and each one of you has to write a reasoned judgment, the time you take to do that in one case, you'd have done 2 others. So that's one reason, not a very persuasive reason, but it's based on the current number of judges. And we had actually resolved that when we get the 11 judges, that is going to be the way, because it is provided for in our rules as a general rule that to begin with we must write single judgments. And so I want to admit to the public that that's one area that we haven't done very well on account of our capacity.
Yeah, because, and I agree with you, it's not a very good reason, because it is one judge who writes. Once you agree, you conference, you say, Judge so-and-so right, and the rest just concur. So it doesn't add, unless the case is of such magnitude that you feel that you need to write single judgments. It's normally you agree as a panel, and then one judge writes and the rest concur, and that's what I've seen in the other jurisdiction. But let me go to the next next question, and this is a quote from a young jurist called Walter Kobe on the Court of Appeal. It's a quote. It's out there, and he says as follows in the platform. If there's a group of people whose ideology is contrary to the spirit, values, and principles of the 2010 Constitution, it is the judges of the Court of Appeal. In fact, if there's a group of people who are irredeemably mired in a legal culture of liberal legalism, that is formalism, positivism, rule-bound technical approach to adjudication associated with the pre-2010 dispensation, and are oblivious to the demands of change in legal culture demanded by the 2010 Constitution, it is the judges of the Court of Appeal. So this is criticism. So, as the president of this court, is this statement true? And probably you would give me examples or give the public examples why you think this statement is not true or correct, as you may.
I'm actually surprised. We thought we were doing our best. We thought we were progressive. And so I do not know where Mr. Kobe did his research, if he's able to identify decisions that he thinks are not progressive, because that's what we encourage. Even among ourselves, we sometimes reflect on our decisions where we have gone two different ways. And we have invited people to come and talk to us from the academia, from the legal practice in the court, in order to be able to have this robust jurisprudence that we talk about in the judiciary. So really...
So can you give us an example of what you consider progressive jurisprudence from the Court of Appeal?
There are many, my lord. There are very many.
Because you have to answer this question, so give us two examples.
We have made decisions in election petitions that have gone to the Supreme Court and upheld, and so many other decisions. This Muruatetu and all these things we are discussing all pass through the Court of Appeal. So I think it is unfair criticism without detail. And so it's to answer...
So for example, he says Mitubel, one of the decisions he discusses, the decision of Mitubel.
Right.
Of course, Mitubel has now been overturned by
Supreme Court.
The Supreme Court. He also mentions this decision which you quoted, this one of the decisions in your this position in Elizabeth Wambui, the one you gave the majority decision. Another one, for example.
Mitubel, yeah, so it's good when somebody criticizes and gives you an example, then you are able to respond. Of course, the Mitubel, the main reason was the way the Court of Appeal did not reflect on the issue of structural interdict. I think that may be a valid criticism. Okay. I want to admit. I don't know what the problem with Wambui case was.
This is, in fact,
the Runda?
Yes, the Runda case, right. About illegally acquired land.
Yes.
And in that respect, I think there have been several decisions that are conflicting on how the courts should deal with the illegally acquired land from the Court of Appeal, and that has actually caused a lot of concern in the lower courts. The Court of Appeal has given conflicting views on that particular issue.
Yes, I can talk about the Runda one. It is more or less Mitubel, if you asked me, except maybe for the area where these people are. They are in Runda. Mitubel was Mitumba village. But save for that, If I sat in Mutubel, I would have done the same as I did in the Runda case, because these are people who settled on that land from the 70s. The road on which they say to have encroached was built, and cars drive through it. The surveyor, government surveyor, confirmed that that stretch of the road, the width was 60 and not 80 meters. And what was going to happen to nearly 300 families was to have their homes demolished. Some homes were 35 million. That's not really a big consideration, but the fact that they had titles issued by the government, the fact that the survey was done by government surveyors. So I would say that if I sat in Mutubel, I would have come to the same conclusion like the Runda decision.
In Mutubel, the court seemed to cast doubt on prescriptive rights. If you read the decision, they seemed to suggest that prescriptive rights are not permitted. You are aware of that?
Yes.
Yes. But then in a very decisive case in Malindi, when you were sitting at Malindi, now in fact this is a case where the 3 judges gave very considered opinion on the constitutionality of adverse possession. You recall Mtana Lewa?
Yes.
Very detailed, and you rebuffed any suggestion that prescriptive rights over land are unconstitutional.
Yes.
So, do you think it's right for the Supreme Court to cast doubt on prescriptive rights, particularly when that was not an issue before them?
That's a tricky one also, because Article 163, I'm bound by their decision, and I can't say that they were wrong. I can only say that we decided Mtana Lewa on the matter that was before us, the question being, is adverse possession unconstitutional? And we said it is not, because there are procedures to be followed, there are conditions to be satisfied before you get title under adverse possession. The possession is not arbitrary. That's what we decided in Malindi.
My position is really, and the question I'm asking this is because you'll be sitting in that court, and just as we have been discussing, the obligation of the court is to be careful about what they talk about, isn't it? They're very circumspect. And by the way, probably that is why the Court of Appeal is always condemned sometimes, because you actually sometimes take a narrow view of the issues you have. So in Mitubel, the issue was squatters on public land. But the court went ahead and suggested, and that's why I'm asking you whether that's a correct assertion by an apex court. It suggested. So you sitting as an appellate court, would you approach that issue in that way?
One thing I was taught when I joined the bench as a judge, having been in administration for so long, those old Court of Appeal judges told me that decide a matter on the basis of what is before you. You may have great ideas you want to put in a matter, wait until the occasion presents itself. And so you're right that we are very, very circumspect when it comes to the matters that we deal with. If you think that you do not want to be bound by a statement that was made, what colloquially would be called out of context or in per curiam, then you go for the main decision that the court made, and you do not have to follow what was not before the court.
And now this brings me back to Muruatetu. because again, it goes to the same way decisions are made. So you have told us, and again, correct me if I'm wrong, the issue in Muruatetu concerned Muruatetu, this man